This litigation happened because, and this should be a lesson for everyone, someone doesn't plan by doing the things we've talked about, and at least a will would have headed off some of this, but maybe all of it. And now this relationship just blows up because there's this dispute. And Dan, I see his side of the story. He's thinking that, even if he has assets, he's thinking that, we were in effect married and she would have wanted this to go to me. Well, we don't know. We don't know whether she'd wanted it to go to him.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome to another episode of Life's Third Act. Today we're picking up with part 2. We're dealing with the life, times, assets, and estate planning of Shelley Duvall. Shelley Duvall, we in our last episode, we talked at length about her life, her career, her successes, the challenges she had later in life. It's kind of a mysterious, last half of her life. So if you haven't watched that, be sure and watch that. But now we've come to the point where we discussed that her death last year was one in which there was no will. There was somebody that she had lived with the last almost 35 years of her life. Since the early 90s or mid-90s, she had been with this person living in Texas. So they weren't married, and this person, of course, would come forward at her death. There was a farm that they owned, and we'll find out whose name that farm was in. And this property in Texas is where she and this other person, Dan Gilroy, lived. I encourage you to watch the first episode to find out about Dan Gilroy. Don't judge this guy too much before you find out a little bit about him. He's an impressive character. So anyway, so he comes forward and says, in effect, I'm like a husband. But she has 3 living brothers. And these are really the only candidates for inheritance. No other siblings. Parents, of course, are gone, no grandparents, et cetera. So, and she had no children. So there's these 3 brothers and on one side, and then there's this guy that she's been living with, Dan Gilroy, for the last 30 plus years. And there's no will. So this ends up in probate, predictably. And so we thought, this case is very much going to hinge upon the subject of common law marriage, it turns out. Some states don't have common law marriage. Missouri doesn't have common law marriage. Texas does. And so Texas kind of it's like a country in many ways, has its own view of things. And among them are things related to common law and marriage and inheritance. So we thought we would benefit if we got one of our experts from Cordell and Cordell, a divorce law expert, who's a partner in Texas in the Austin office, a prominent attorney with Cordell and Cordell, and prominent in the bar nationally in domestic relations. I thought I'd be able to get her on in the first segment, the first half of this show on Shelley, but we couldn't do that. So we got her on today. And so I want you to know something about her. She's been with Cordell and Cordell some 15 years or so, and she's practiced nothing but domestic relations. So she's an authority in that area. She's very active with the Texas bar. She speaks not only to lawyers in Texas about the practice of family law, but beyond Texas. And so she's a very prominent speaker in the profession. So Kelly Burris, thank you for coming aboard and for giving us some time today to do this.
Well, thank you so much for having me on.
So now I know that, I didn't give you much information. We exchanged some emails, and I kind of said, look, we'd love to have you on to talk about this. This was just a couple days ago. So I gave her very little notice, but I knew that she'd know off the top of her head how to answer these questions and give us some insight. So tell me what your thoughts are.
Well, and as soon as I heard the topic, I went down the rabbit hole. And
I would have expected that. Go ahead.
So I did find out a little bit more information, and it's a really interesting case. As a matter of fact, Blanco is not far from where I live. I probably live about 30, 40 minutes from there. And it's a beautiful area. It's Texas Hill Country. It's gorgeous. I can totally see why she wanted to settle out there. But yeah, I mean, common law marriage in Texas, I've had several of these cases throughout my career, and it's the same rules apply for probate as it does for marriage, in that you essentially have to prove three things. So a lot of people come in and want to, when I have consults and things like that, they'll say, "Oh, I think we're common law married. We live together," and that alone isn't sufficient. So they can live together for 35 years. They can even have kids together, and that is not common law marriage. So they have to. The other two elements are they have to hold out as a married couple. So they have to basically tell everybody else, tell other people that they're married. And they have to have an agreement to be married. And the agreement can be inferred from the actions of the parties.
So it doesn't have to be in writing, the agreement?
Right. You don't have to necessarily have an agreement in writing. It can be verbal, and it can be sort of assumed. So those two other aspects sort of go hand in hand, because if the holding out is sufficient, then the court can infer that there's an agreement to be married.
So tell me about the holding out. What do the cases look like when somebody has held themselves out? Does that mean that they've been at cocktail parties or something and said we're married?
Or they don't have wandering eyes for someone else? I only have eyes for you kind of thing.
Yeah, like I've had a couple of cases where it was literally we were trying to get witnesses to say, hey, these parties introduced, the spouse that's contesting it introduced the other spouse as their husband or wife. Usually what we love to see is, they file joint tax returns. They put each other on their insurance as a spouse. They brought property together. So that is more solid evidence, but it can be, if you have enough witnesses that can say, hey, these people introduced each other as their spouses, that can be sufficient for holding out. So the law is a little vague. There's a lot of cases. So there's not any sort of defined thing that says, okay, if you do this, then that's considered holding out and you're good. It's very much a case-by-case basis.
And it wouldn't matter how many years they've been together, whether it's 1 year or 35.
That probably helps, doesn't it?
It does help, but you still have to have those other two elements. So I thought what was interesting about this case when I was when I went down the rabbit hole on Google, every article that I saw, it never said and referred to this guy as her spouse. It said partner. And there were multiple articles, never married. And so, if you just use the Google, it didn't appear that they were holding out. But of course, then we don't know about their private lives and how they introduced each other, to friends and family, or if they ever filed joint tax returns or anything like that. So, that element is certainly, I'm sure that was the element that was the big issue in this case.
Yeah, and I noticed that that soon after the death, I think it might have been Dan that stepped forward first, but it happened pretty quickly. Whenever Shelley died in, what month was it? Was it July?
July 11th.
In July of 24. Pretty shortly thereafter, there was a petition filed with the court for someone to be appointed the administrator, which for those of you who don't know what that is, the administrator is someone who's appointed when there is no will, as opposed to a personal representative or executor in some states. So an administrator is in many states, apparently in Texas, is used to refer to that person that says, look, let me be in charge of the estate. I'll see to it that we identify creditors, that we determine proper heirship, meaning the people who should inherit if there is no will. I'll take care of all those things. So it is an important position to hold, and it can be influential, that position. So there was a dispute pretty quickly about who is going to be the administrator. And maybe it's the brothers that filed first, and then thereafter that was disputed by a filing from Dan Gilroy. Have you had a chance to look at any of that?
I have. I think it was Dan that filed first, and then the brothers disputed.
Okay.
And, I would imagine it probably, that property was titled, I looked it up, and that property it looks like it was titled only in her name. So it looks like he didn't have an interest in that property at all. And I can imagine, you live, I think they bought it she bought it in 2010. So, he'd lived there for 15 years. And then all of a sudden.
Is there any kind of is it called a squatter Right? If someone lives somewhere long enough.
No, adverse possession, but that wouldn't apply here because it was consensual that he was living there.
And if he had, even if she'd had a will that willed everything to somebody else, if he'd been her spouse, he would have had a life estate in that property and been able to remain on the property. But if he's not her spouse and he's not on the title anywhere, then, I mean, granted, my knowledge of estate law is a little bit limited, but I've had this issue come up recently in my own life. So I know I've done a lot of research recently about probate.
You had a family member pass away.
I did. Yeah, my dad passed not too long ago. So I just finished probating his estate. So I knew a little bit before then, but I certainly know a lot more now. And yeah, apparently, it looks like there was no deed transfer or anything. There was no right of survivorship on the deed. He wasn't her, if he's not her common law spouse, then he doesn't even have a life estate to that property, and he has to leave.
Well, you would think too that with her three brothers, that they would have known whether or not they were common law.
Well, they took the position that there wasn't. I mean, that was what launched this probate fight, for lack of a better word, and that this litigation happened because, and this should be a lesson for everyone, someone doesn't plan by doing the things we've talked about, and at least a will would have headed off some of this, but maybe all of it. But the way this turns out, it really set the stage for people that may have gotten along well together. I wonder if Dan had a good relationship with her brothers, and I'm going to speculate that he probably did, because Dan was the one there around her and was really the more rational, I'm confident, of the two. And now this relationship just blows up because there's this dispute. And Dan, I see his side of the story. He's thinking that, even if he has assets, he's thinking that, we were in effect married and she would have wanted this to go to me. Well, we don't know. We don't know whether she'd have wanted it to go to him. But can't you see why, Kelly, wouldn't a probate judge be inclined to look for a marital conclusion here because they had been with each other so long and apparently to the exclusion of anyone else, and that she was a little mentally off. So the fact that she didn't actually marry him, it may be the same thing about the estate planning. And where do you think a judge's sympathies would go?
Well, I do think he's really sympathetic. I mean, obviously, I don't know these people personally, but 35 years with somebody and then going through all of those mental health issues and everything else, and it sounds like her estate wasn't much more than the property. So, I don't know. Hearing the story, I was pretty sympathetic for the guy. But ultimately, the law is the law, and I'm sure that if there was any. They did have a jury trial. It looks like they had a jury demand on file at one point, and I don't know who filed that.
I think Dan. I saw that in the court's memos that he asked for a jury trial.
Which makes sense, right? Because if he doesn't have as good of evidence on the holding out, he's going to want to appeal to the sympathy of a jury. Yeah. And that isn't maybe going to be as stringent or strict on the law and following what the law is as a judge would be, especially a probate judge.
Yeah, that's a good point. And that probably was his strategy. Often if the details or the technicalities are not in your favor, it is often better to have a jury because they're just going to look at the substance of the matter and say, does this seem right or fair or just? So fortunately, this case was one of those where it didn't last real long. There wasn't the vast amount of money that could have been spent, thankfully, because the dollars weren't there to justify it. I mean, if you had a $10 million estate, then those who find themselves in this litigation often reason that, well, we need to keep going because what's at stake here justifies the additional lawyer fees. But in a case like this, I think both sides maybe recognize that, if we keep fighting this, we're just going to chew up far more than what's at dispute here. And I'd be curious how much they spent already. But I guess we can go we can go ahead to the end of the story, so to speak, on the litigation and say that there was a settlement. The settlement happened, when was it? In early March of this year? Mm-hmm. Did you have a chance to look at any of the on the order relating to the settlement? I know that you're a divorce lawyer, but I told him to go ahead and send you.
I was able to kind of look at the proposed heirship, and then there was another order, and it looks like they reached a mediated settlement agreement, which is binding in Texas. So they settled, and Dan got half, and then the brothers split the remainder. So that's why I was saying that I think it's mostly the property, because it mentions the property and the sale of the property, and so that's
so they are going to. You think they're selling the property? I
think so. It sounds like that's what's happening. And then they'll split, between him and then the brothers, they'll split it.
So it looks like behind the scenes that this guardian ad litem that they appointed, which must be a Texas thing for this purpose. We have guardian ad litems, but we appoint them for things like very personal, like custody of kids or care of an older person or an incompetent person. But it appeared that the guardian ad litem was to make a determination regarding heirship, which sounded like to make a determination regarding whether or not this was in a recommendation. The judge ultimately, for those of you who don't know, the judge ultimately decides, but a guardian ad litem just prepares a report. And there was a guardian ad litem that was appointed, and I don't know specifically or directly the contents of that report, but it looks like that report regarding whether or not these parties were married, it looks like it may have concluded that they were. Was that your read on it, since we're the judge in?
Yeah, I don't know. Because the guardian, protecting would be there to protect the nature of the estate, and I would assume what she wants. I will say I'm taxing my probate knowledge a little bit here on what guardians do.
Well, we don't know Texas law at all, so go ahead.
But yeah, so I think ultimately the holding out in those more legal-based issues would be the judge or the jury. So I think that the common law, whether or not they were common law married, would have been sort of the, what the judge, or in this case, if they'd gone to a jury,
it wouldn't have been in the province of the guardian ad litem, you're saying?
Yeah, I wouldn't imagine it would be, because it's more of a legal conclusion. Yeah. And usually those guardians don't make legal conclusions. It's more, what's in the best interest.
Maybe this is it then. Maybe what the guardian's doing is making a conclusion regarding the facts related to the necessity of that. But either way, the good news is that the parties decided to settle. And that tells me that either the brothers and Dan came to the conclusion that, look, this is just going to be ugly. Let's just go ahead and settle it. But Dan got pretty much what he was wanting. I think, well, no, that's not true. Because if they had in fact been married, I think that Dan would have gotten all of it. The brothers would have had no claim. So that where they ended up settling, for those who don't know, is that half went to Dan and half went to the brothers. The reason I first thought that that's the way the court might have ruled is because I'm thinking there are children. And that's common in many states. When intestate succession, they'll give half to surviving spouse, and then if there are minor children or a very close family member, sometimes a parent, they may have half that's available for a parent if there are no other kids. So, but in this case, there were none of those close relatives as a court would define them if there's a spouse. So they both compromised. Everybody compromised. So I guess so. Maybe this is, as we sit here and talk about it, I'm growing more confident that we can put together what happened. I think they both saw risks, and they both felt that, look, we could end up with nothing, which would be the case. Dan would end up with nothing if it were concluded that there was no common law marriage. He'd get nothing. On the other hand, if there was one, the brothers would get nothing. So it was literally an all or nothing dispute. And so I can see why they both get partially down the road, having spent, they each have spent thousands of dollars, maybe certainly not 6 digits, and probably not 5 digits, but I would say upper single digits of thousands. and maybe as little as 5 or 4,000, but it's still a significant amount of money.
Yeah, and they're no spring chickens. I mean that in the nicest way. I mean, they're all probably in their late 60s, 70s. So
yeah,
they don't want to wait forever for that money.
So in that part of Texas, are there a lot of rural properties that kind of fit this description? That's a thing down there, and it's called the Hill Country. The Hill Country, I always thought that was just Austin. It goes beyond Austin.
It does. So it starts kind of it's mostly southwest and west of the Austin area. And so Austin sort of starts it, and then it just sort of moves southwest and kind of through San Antonio some. So that whole region. And it's really beautiful. That's kind of the wine country of Texas. There's just that 290 that runs right through Blanco. That's just beautiful wine country out there. And there's just one after the other, all the way to Fredericksburg, which is kind of a touristy little town out there. So, I mean, she picked an absolutely gorgeous area to live in.
So tell me as we wrap up here, tell me what advice you would offer someone who they're living with someone and maybe they've been living with this person a while and they're thinking about their estate planning. So we'll assume this is not somebody young. This is somebody, say, 60 or over. And I think there are a lot of those people out there. They don't want to make a commitment. Their spouse has died or something, or they got divorced after a 20-year marriage. And so they're living with someone. Mm-hmm. What advice would you give someone who comes to you and says, I'm going to do my estate planning, but tell me how I can make us married and still feel safe for, if this comes apart, I have children I want to protect that are not children of this marriage. So this is somebody who's come to a divorce lawyer thinking specifically about how to create a marital relationship so that they can have better estate planning.
Sure. Yeah, it's that is the concern. If you're married, really in Texas, it's still a community property. So even if you're married and you enter into a will and you don't give any of your property to your spouse, you give it all to your children. Well, approximately 50%, the community estate, 50% of the community estate will still go to your spouse, is my understanding. Again, limited in probate, but
no, I think that's right.
Yeah. So it's, it really is making sure that you're planning, but also understanding that if you're married to someone, they're going to get, it's not that they're going to get booted out of the house and all of the money is going to go to the kids, even if they're kids from that marriage. I mean, they're going to have an interest in that state, even if you do a will that completely 100% gives it to somebody else. But with that said, I had an interesting case years and years and years ago about a life estate, a family that had a large property, and the man that died had remarried and thought that the entire estate, because he had owned it prior to marriage, was going to go to the kids, I think. And because Texas has a life estate, the second wife ended up being able to stay in that house on that ranch property for the rest of her life, even though it was his separate property prior to the marriage. And the ranch went to the kids, but she got to stay in a life estate. So there are all those little weird kind of laws that you don't know about, why it's really important to get some really good estate planning done and know what that is and know what it means when you do get married, or if you choose not to get married, what that can mean for an estate.
And I think that's one thing that people don't realize is the legal impact of being married. And it's not just estate planning. It's in a lot of ways, of course, in life, in terms of assets and liabilities and debts that one party might owe. You might discover you owe it too. And so there are lots of grave consequences to being married. And I think that you raise a good point, Kelly, where my instinct is to go to, so you want to be married, let's do that, and then let's figure out the consequence, how to protect you from the consequences. But you just raised, the obvious alternative, and that's that maybe it doesn't make sense for some people. I mean, I come from a religious tradition where, marriage is important, period. So a lot of my clients came from that tradition too, and so they insist on being married, but with that comes some issues that we have to sort through for estate planning purposes. And I want to call attention to the point that you raised, that is a fair point, and that there is the option of not being married, like Dan Gilroy did. I think Dan chose to not get married. I'm speculating. We don't know. But if he had these assets and these other, financial relationships, professionally and otherwise, we don't know all of his family, interactions and whatnot, dynamics. So I think that could have been a very premeditated decision that he didn't want to marry someone. We could certainly speculate someone in his position might conclude that. So you're pointing out the decision to that person in your office may be to say, well, it makes more sense then, given your priorities, to not marry, and furthermore, do some estate planning to make clear what your intentions are. But now let's talk about the person who says, okay, but I want to marry. I have a religious faith, whatever it is, I want to be married. So do you do prenups a lot? And I know that our firm does a lot of prenups. With community property estates, it's a little different, is it not, or no?
Well, that's exactly what I was going to say. That if you have kiddos from a previous marriage and you're looking to get remarried, I almost, and you want your kids to have, some say in your estate, or you want to make sure you're separate property, you have to have a premarital agreement and a really good estate planner if you're going to do that. Because there are all of these little weird things that, can happen with your estate that you just don't even know. You don't even know about it. So at least, if nothing else, get the advice of an estate planning attorney and potentially a family law attorney, because prenups, the parties can agree to not do that life estate. They can agree to limit that life estate. So there's all kinds of things we can do in a prenup to prevent those kinds of problems later on down the line, where you can continue to have a successful, happy marriage. Parties can change those things as the marriage goes on. So 10 years in, they can even write in, say, hey, if we're married 10 years, at that point, I want this separate property house to go to my spouse. But prior to that, if we break up before then, I don't want that to happen, or if I die before 10 years. So there's all these weird things that we can do in a prenuptial agreement, and they're really kind of hard to break if you do them right. I mean, it's really difficult if you do them correctly.
So even the assumptions in a community property state about, co-ownership or 50-50 ownership of assets acquired during the marriage, even that can be dealt with preemptively with a prenup?
Absolutely. You can basically contract. You can do a contract and a prenup, or even a postnup, we call them partition agreements or postnups, that bypasses as much of that as you want. The only thing you can't really contract for with respect in Texas is minor children, so child support, possession, that kind of stuff. But as far as property is concerned, most of the prenups I do have not only a divorce section, but an estate section. So it'll say, in the event the marriage ends in divorce, this happens. In the event the marriage ends in death, then this happens. So we plan in our prenups for both of those eventualities in most cases.
Very good. So, yeah, I think that's probably maybe the core issue as we look at the facts related to Shelley Duvall's estate planning and the way things turned out is this relationship that she had with Gilroy, and the fact that there was no prenup, there was nothing, there wasn't a marriage, there wasn't even a separation agreement where you don't marry, but you have an agreement. There just was nothing there. And so, it was very foreseeable there would be some conflict and maybe what are probably lasting wounds between these men that might have been friends at one time. Thankfully, it did end with a settlement, but it doesn't mean it ended with a happy settlement. Maybe both felt cheated. But anyway, I appreciate your coming on. You really added a dimension to this subject that I think is at the heart as we talk about things that should have been done. Yeah. Other than having, in addition to you, Kelly, I could have had on somebody who is a mental health expert to talk about what solutions were there for Shelley in this, when she's flailing out there so badly and seems on her own. Mm-hmm. I mean, though Dan's there, we don't know what's going on with that.
And her brothers and
Yeah, our brothers are somewhere nearby.
Yeah, didn't anybody notice?
They all knew. The question is, was there anything that could have been done? And we don't know. But okay, very interesting discussion. Thank you, Kelly Burris, from our Austin office of Cordell and Cordell.
Thank you again for having me on.
Yeah, and I'm sure we'll do this again. So I hope you found this interesting. This has been another episode of Life's Third Act. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell and Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.